Well, good evening, everyone, and welcome back to AJ102, Introduction to Law Enforcement and Criminal Justice. Tonight's lecture is going to be on Chapter 13, which is going to cover U.S. courts. Now, because of the way the chapter is basically structured within the text, there are a lot of definitions, so we might be kind of jumping around a little bit from definition to definition, but a suggestion would be that you utilize the resources at the beginning of your chapter, the key terms, and I believe in this chapter there's probably about 35 to 40 key terms that will help you understand as we go through this particular lecture, or you can go back and define those key terms afterwards. But I think this is really going to be one of those times where it would be beneficial to go through all of the key terms. So I'm going to leave the learning objectives to you to read and kind of decide as you go through these and you read these, figure out how much you've learned as you've watched the lecture or looked at the PowerPoints or what have you. And I also put in a pretty cool video on the jury selection process. And the case is Edmondson versus Leesville Concrete Company. And it's about a 25-minute video, but it's really good, and it shows you pretty much how that jury selection process was formed, and some problems that came about, and some solutions to the problems that were brought about by this particular case, and how we actually select juries today. So take the time to watch that. So the criminal justice system comprises three major components: law enforcement, courts, and corrections. And each component acts independently and interdependently as the total system functions. Now, what happens in one component affects the other two components. So if law enforcement arrests and elects to prosecute thousands of people, this could create a problem with overcrowded dockets in the court area. And likewise, if the courts sentence thousands of defendants, the correctional system can become overcrowded, resulting in early release of prisoners and potential problems for law enforcement. Now, further complicating this diagram, our criminal justice system is the existence of a separate but parallel justice system. So within law enforcement, or that law enforcement component on the left, juveniles may be assigned to a separate division or may be handled by all officers. So there's three components, but there is the existence of that separate but parallel juvenile justice system, which kind of throws a wrench into some of the things that we're going to talk about. And we're going to hit a little bit on the juvenile justice system as we get going. Now, with what I've just said, police officers must become familiar with the courts as well as each step of the criminal justice process, because they may find themselves playing important roles in this component of the criminal justice system. And they must also be familiar with what they call criminal jurisprudence. And jurisprudence is the science or the philosophy of law in a given area or a department of law. Now, first, just as law enforcement officers are the gatekeepers for the criminal justice system, using their discretion about who to arrest, prosecutors are the gatekeepers to the judicial system, using their discretion to determine who to charge and to bring to trial. And sometimes we do get a little friction that occurs between the officers and the prosecution when they disagree whether or not a case is strong enough to bring to trial. Now second, if the case does go to trial, officers are frequently called on to testify. Therefore, officers should be familiar with the courtroom itself, as well as how it operates and their role as a government witness. And they should also recognize the various levels of the courts, like the dual federal and state organization of our judicial system, and that they, or at least their reports, could end up in the U.S. Supreme Court, which is like the highest court. So, I mean, how cool is that, I guess, as long as it's on a positive note. But anyway, in addition, officers may find themselves sometimes frustrated by actions taken by the courts unless they understand the restrictions under which the courts operate. For example, the Sixth Amendment requires that each suspect is given a speedy trial. And this may force law enforcement to hasten its investigation or even lose valuable evidence if officers detain a suspect for an unreasonable amount of time. And pretrial release may also anger police, as may plea bargains in which they really don't have a lot of say. And especially frustrating for officers would be when defendants are found not guilty because of what we call a technicality, which often results from some unintentional but unconstitutional action by the police officer. So maybe we didn't do something procedurally correct, and our case might get thrown out of court. And then finally, prisoners released on parole and defendants sentenced to or released on probation are of valid concern. And although the corrections portion of the criminal justice system is technically responsible for these individuals, in reality, these parolees and probationers are living within some local department's jurisdiction where officers are responsible for keeping the peace, right? Now, the Bureau of Justice Statistics reports that at year end in 2014, there were approximately 4.7 million adults under community supervision, and 82% were probation. And a sentence of probation, just to kind of finish up this area, may anger and frustrate law enforcement officers who work the case and see such sentences as contributing to that, remember that revolving door of the criminal justice system, and law enforcement catches the bad guys and the system kind of lets them go. So the role of law enforcement in community supervision is not only is it very, very important, it'll be discussed more in the next chapter when we talk about the correction system. So how do we look at the court system, and what is it made of? And again, we're going to go over some definitions, and this may vary a little bit from state to state, but for the most part, it's pretty specific. But again, different states do things a little bit differently, okay? So U.S. courts operate within a highly structured framework that may vary greatly from state to state, like I said, and many dualities exist within this framework, and one such duality could be their jurisdiction, which refers to a geographic area and to a court's authority to try or adjudicate a case or to hear an appeal. The duality part being that of original versus appellate jurisdiction, and we'll get to that. So whereas a court with original jurisdiction has the authority to try a case, a court with appellate jurisdiction has the authority to hear an appeal to set aside a conviction without holding a trial. Now, in some cases, a court has both types of jurisdiction. So, for example, the U.S. Supreme Court. And that term adjudication that I mentioned a minute ago is the process of judicially deciding a legal case. A court with authority to adjudicate cases is often referred to as the trial court. And because such courts are often the first to record the proceedings, they are also referred to as the court of record. And a court of last resort refers to the highest court to which a case may be appealed. Further complicating our court system is the duality of an adult and a juvenile court system, as well as that of felony courts and misdemeanor court, both which we're going to kind of get to in just a little bit. So original jurisdiction, a court's power to take a case, to try it and decide it. In contrast to an appellate court that hears appeals to the decisions from that original court. And that appellate court is a higher court with the power to hear and decide an appeal to the decision of an original court without holding a trial. And then if the person gets off at the end, or I'm sorry, the phrase adjudication that we went over, that's the process of judicially deciding a legal case. So this structured framework, the original jurisdiction we just went over, the appellate jurisdiction, and then what about like the state court system? Well, each state's constitution and statutory law establishes its court structure, and consequently, great variety exists in the type of courts established, the names by which they might be known, and even the number of levels in that hierarchy. And the hierarchy at the state level often goes from courts of special or limited jurisdiction, including small claims or justice of the peace courts or things like that, to trial courts of original and general jurisdiction courts, including like probate, divorce, county court, circuit court, district court, and superior court, to intermediate appellate courts up to the state Supreme Court. And I've got a diagram coming in just a minute that will kind of help you figure all this out. Now, most cases originate in what we call a municipal or county court. And as such, these courts would be the ones that law enforcement officers would most often be called to testify. So your case would typically go to like a municipal or a county court. And although municipalities and counties are self-governed and have their own courts, they need to comply with state and federal laws. And in some states, cases may be appealed to an intermediate appellate court. In every state, though, the state Supreme Court is the court of last resort at that level. And cases that go beyond that point move into the federal court system. So, okay, so I know it's kind of difficult to understand, but just a couple more and then we'll be there. But let's take a quick look at this slide right here. Now, on the federal end, you have magistrate courts, what we're just not going to talk a lot about, but we're going to talk about like district courts. So this is kind of where we would start when we start thinking about district courts. And the next level up in federal court then would be the Circuit Court of Appeals. Now, I'm pretty sure at the beginning of this chapter, I posted, I believe, 5 videos that are about probably 10 to 12 minutes long, maybe a little bit longer, and they discuss each court in detail. So while I know it's not the most exciting thing, you really need to watch those videos to get a better handle on that court system and what role it plays. So while there are magistrate courts, we're going to start here at the district court level. And then if the case goes higher in the federal court, it goes to the Circuit Court of Appeals. And then if it needs to go higher, it's going to go to the Supreme Court of the United States. And this is the highest court in the land. Now, on the state side, okay, you will have basically trial courts. And there are some that are a little bit lower. But you'll have trial courts or those county courts or what we call superior courts. This is where you would go testify. And then you have intermediate courts of appeals. And then if you go further higher, you go to the state the state court, okay, usually called the Supreme Court. So this is the state Supreme Court. Remember, there's a federal and a state, and every state has a state Supreme Court. And if it doesn't work out here, your last chance is going to be going this way over to the United States Supreme Court. And then we're going to talk more about that in a minute, but that just kind of hopefully whets your appetite on how the court systems function. So what about juvenile court? For more than a century, the United States has had a court system separate from the adult court to deal with juveniles. Now, in 1899, Illinois passed the Juvenile Court Act, creating the first juvenile court in Cook County, and the beginning of a era of what we call social jurisprudence. And the court's primary purpose was to help rehabilitate wayward kids so that they would become productive, community members. The act, however, also gave expanded jurisdiction to the juvenile court in handling youths who broke the law and in regulating the treatment and control of dependent, neglected, or delinquent kids. Now, the Juvenile Court Act also equated poor and abused children with delinquent and criminal children and provided that they be treated in essentially the same way, establishing kind of a one-pot approach. And most juvenile courts today have this same dual charge. Now these courts are also grounded in the English common law doctrine of what they call parens patriae, and you can say it in a couple of different fashions, but that's about the best I can do, so you're going to have to kind of go with it. But anyway, that means that the state is responsible for the general protection of all people within its jurisdiction who cannot protect themselves, and that included children. Now juvenile courts again vary from state to state, but most begin with some sort of intake, usually starting with what they call a petition. And this is a petition is a document alleging a juvenile as a delinquent, a status offender, or a dependent, and asking the court to assume jurisdiction over or of that child. And it is the formal process for bringing a matter before the juvenile court. Well, what about the federal court? And we're kind of walking through each piece here. Well, just as with states, the courts, or just like with state courts, a system or a hierarchy exists among federal courts. And again, if you watch those videos, you'll get a lot better of an idea of what I'm talking about. And the hierarchy at the state level often goes from courts of, like we talked about before, special or limited jurisdiction, to trial courts. Those are the ones that we are kind of used to dealing with. Let's say courts of original origin, or trial courts, or jurisdictional courts, and even superior courts. To remember, intermediate appellate courts. So we're here. So we have the lower courts, and then we have the trial courts, and then we have these intermediate courts, and then all the way up to the state Supreme Court. Well, the feds has basically 4 tiers. And while we don't spend a lot of time at the bottom, there are what they call magistrate courts, or non-Article 3 courts, and I'll explain that in a few minutes. And then we go into kind of the district courts, which are here, and then appellate courts are right here, and then of course the U.S. Supreme Court. And a state may be divided into federal districts, and districts never cross state lines. There are 94 district courts across the United States and its territories, 89 districts in the 50 states, as well as a separate district court in the District of Columbia, and 4 territorial district courts in Guam, the Northern Mariana Islands, Puerto Rico, and the Virgin Islands. And the appellate courts are organized into circuits, each with circuit encompassing several like states. And currently there are 12 federal circuits that divide the United States into different regions. And again, if you watch those videos, you'd be able to kind of understand that. Well, what about the Supreme Court? And then we're going to kind of move on. Well, the United States Supreme Court is the high court of last resort in this country and is presided over by 9 justices appointed by the President of the United States, subject to confirmation. And the President also appoints a Chief Justice who assigns cases to the other justices. So, again, the high court. So, U.S. courts, kind of as a review, operate within this highly structured framework that may vary greatly from state to state. And we know many dualities exist within this framework. And one of those dualities is what? It's jurisdiction, which refers to that geographic area and to a court's authority to try or adjudicate a case or to hear an appeal, etc. And a court with original jurisdiction has the authority to try cases. A court with appellate authority has the authority to hear an appeal to set aside a conviction without holding a trial. And in some cases, a court has both types of jurisdiction, like the U.S. Supreme Court. And then we've already gone over the term, what adjudication means. And a court with authority to adjudicate cases is often called a trial court. That's the lowest one, remember? Because such courts are often the court of first record, or the first ones to record the proceedings. And a court of last resort, which would be which one? That would be the highest court in which a case may be appealed. So you're catching on now, and maybe the review is good for you. And each state's constitution and statutory law establish the structure. And most cases originate in that municipal or county court. Remember we talked about that? That's the court that you would probably testify in most of the time. And in some states, cases may be appealed to an intermediate court or an intermediate court like an appellate court. But in every state, the state Supreme Court is that court of last resort. And here's kind of a really basic diagram for cases and for the state side. Now, we're not going to go, remember there's 4 on each one of those. There are those limited trial courts that would actually be like down here, but we're going to kind of just jump ahead and say, hey, you know what, there's these 3 major pieces. There's the trial courts, there's the court of appeal, and then there's the Supreme Court. And this is kind of what the state Supreme Court system looks like. Now, the appellate court, remember, is a higher court and has the power to hear and decide an appeal to the decision of a lower or original court without holding a trial. So they don't retry the whole thing. They ask for specific facts and they look for issues that were either done or not done, procedural, constitutional, etc. So there is no second trial. And then I'm going to skip past the juvenile courts because we really kind of already hit on these particular facts. A couple of other things, though, I guess, that I'm just noticing in this juvenile court area. We know the petition is the document alleging a juvenile is a delinquent, a status offender, etc. But there's also something called a disposition hearing, and this is where the judge will provide the disposition, to which there are several options. And an adjudication hearing is comparable to like a preliminary hearing in adult court. And one other phrase that kind of comes to mind is an emancipated minor, and that's a minor not yet of legal age, basically freed from their parents' control. So we talked a lot about the state court, and we had the review, and I know it took some time, but I think that helped us gain some confidence as we talk about, you know, the state court. Well, now let's kind of do a little review or refresher on the federal court. So just as with state courts, a hierarchy exists among those federal courts. And the federal court system has 4 tiers. And the 4th one would be like down here, remember, but we're not going to spend time on the magistrate courts. We're going to go right to the district courts. So kind of like with states, how I put it into the three major pieces, we're going to look at the three major pieces of the federal court system. So magistrate courts was the fourth. That's like here, but it's not there. District courts. And again, so this is the lowest level in the federal system. 94 judicial districts in 50 states and territories. Okay, gives you a little bit of information about it. Appellate courts. This is the court of appeal. Not appeals, court of appeal, and that does make a difference when you say it. And this is the intermediate level in the federal system. And then of course you have the Supreme Court, and you all have probably heard of the Supreme Court. And this is the highest court in the federal system. It's the highest court in the land, with 9 justices meeting in Washington, D.C. And appeals are heard through what they call a writ of certiorari, and it's a process, and we'll talk about that in a minute. And they don't hear a lot of cases, and they get to decide which cases they actually want to hear. And we'll talk a little bit more about that as well, because it's kind of a interesting process. So the U.S. Supreme Court, highest court of last resort in this county, presided over by 9 justices, appointed by the President of the United States, subject to Senate confirmation. And the President also appoints the Chief Justice, who assigns the other cases to the other justices. And they basically serve for life until they either retire or maybe get impeached or something like that. But for the most part, they serve for life. And in order to get a case, like I talked about a minute ago, to the highest court of the land, they're going to need this particular document, and it's called a writ of certiorari. So the Constitution established tenure for life on good behavior, if you will. And therefore, the only way to remove a justice is through impeachment, unless voluntary retirement can be obtained. Now, when the Supreme Court decides to hear a case, it grants this thing they call the writ of certiorari. And it's a request for a transcript of the proceedings of the case for review. And when the Supreme Court rules on a case, the ruling becomes really cool. It becomes something called precedent, commonly referred to as a landmark decision, like a case like Terry versus Ohio, or Mapp versus Ohio, or Miranda versus Arizona, cases you've probably heard of, which must be honored by all lower courts. And the use of precedent in the legal system gives the Supreme Court power to influence and even mold the everyday operating procedures of law enforcement, because they're getting these precedent cases out that either allow us to do certain things or don't allow us to do certain things. So again, these precedent cases play a huge role in what we're doing, because they influence and they mold the everyday operating procedures of police, which would be you out in the field. Well, what about some other courts? And there's a bunch of them, and we're not going to spend a ton of time going through each one. But there are things like tribal courts. So a tribal court system includes trial and appellate courts, as well as specialized civil and criminal and family and healing and wellness and juvenile and drug courts. And these courts hear cases pertaining to Native American law that affect both Native Americans and non-Native Americans living and or operating a business within the jurisdiction of a Native American government. Well, community courts, and some of these you've probably heard of, and we'll give you just a little taste of what they are. These are neighborhood-based and seek to solve local problems. And they bring together local resources and create problem-solving partnerships with community groups, government agencies, and social service. And similar to other collaborative justice courts, community courts aim to improve efficiency in judicial proceedings. And it's kind of an interesting concept. Now, there are currently more than 36 community courts operating throughout the country, and their mounting successes are well recognized. But they deal a lot with quality of life type crimes and things like that. And here's some other kind of ones, and we talked about problem-solving courts. So these are kind of an interesting thing. And problem-solving courts seek to achieve tangible outcomes for victims, offenders, and society. And these include reductions in, let's say, recidivism. That's that in and out of jail thing. Reduce stays in foster care for kids, or increase sobriety for adults, or reentry courts for prior offenders, and healthier communities. And problem-solving courts rely on the active use of judicial authority to solve problems and to change behavior of those litigants. And these courts do not pass off cases to other judges, probation departments, or community-based treatment programs. Judges at problem-solving courts, they stay involved with the cases throughout the entire post-adjudication process. And again, they use this collaborative problem-solving type function, and there are more than 3,000 nationwide. Well, what about, interesting, what's a drug court? Well, the most well-known and researched specialized court would be a drug court. And drug courts are community-based courts designed to reflect community concern and priorities, access to community resources, and seek community participation and support. And although the structure, scope, and target populations of drug courts vary from one jurisdiction to another, the goals remain the same: to reduce recidivism, that in and out of jail thing, and substance abuse, and rehabilitate participants. And well, there's DUI courts. So as with drug courts, DUI courts are being established to protect public safety and to reduce recidivism by attacking the root cause of impaired driving and alcohol and substance abuse. So the mission of sobriety and DUI courts would be to hold offenders accountable for their actions and change their behavior to end that cycle of abuse, recidivism, DUIs, and drugs, and things like that. What about domestic violence courts? Well, according to the Center for Court Innovation, an important part of domestic violence court involves putting victims in touch immediately with social services. And victim safety is the cornerstone of domestic violence court. Every victim should be given immediate access to an advocate who can assist with things like safety planning and explain court procedures. Mental health courts, well, those are modeled after drug courts, and they practice therapeutic jurisprudence, often altering the traditional dynamics of a courtroom. And there's kind of a list of other things that the courts feature that you can find on page 539. Homeless courts help homeless defendants resolve outstanding misdemeanor criminal cases. Reentry courts, kind of a relatively new thing, where there are presently at least 24 throughout the country, and reentry courts serve parolees before they're released from incarceration by working with correctional staff to develop detailed profiles of participating inmates that might include information about medical status or addiction or criminal involvement, vocational skills, and family composition. And teen and youth courts, also called youth court, and peer courts are designed to address a variety of youthful problems and behaviors like underage drinking and substance abuse and truancy, and other related kind of status offenses. So, man, there's just a lot of stuff in there. And they even have juvenile drug courts and gun courts, and just a bunch of different stuff. So now let's talk a little bit about the courts themselves and the process. And our court process is an adversary system. So our criminal justice system is based on that adversary system, the accuser versus the accused. However, the accused, remember, is innocent until proven guilty or proven to the contrary is clearly established. And that's what our system is based on. Imagine if it was the other way. I mean, I just wonder, you're guilty until you can prove yourself innocent. So that's kind of just an interesting thing for me when you kind of think of that. Now, what they call here this presumption of innocence, another term, it means that the accused is assumed innocent until proof of the contrary is clearly established. On the side of the accused are the defendant and the defense attorney, and on the side of the accuser is the citizen or victim and the prosecutor and the police officer. And those folks that I just mentioned, well, they bear the burden of proof. And an impartial judge or jury is going to hear both sides of that case. And then they reach a decision whether the accuser has proven the accused guilty beyond a reasonable doubt. And in our adversary criminal justice system, it requires that the accuser prove beyond a reasonable doubt, okay, to a judge or jury that the accused is guilty of that crime. And reasonable doubt is a more stringent evidentiary standard than in a civil trial. So in criminal, you need this proof beyond a reasonable doubt, but in a civil trial, you need something that is kind of called, well, not kind of called, it is called preponderance of the evidence. And that's a greater weight of the evidence. One side is a little bit more credible than the other. And that standard is used again in civil. Now, if you look on page 541 in your textbook, there is a chart of evidentiary standards of proof and their corresponding degree of certainty. So you can look at that. And it has this same information, but the chart kind of expands it a little bit more. And they talk about absolute certainty and beyond reasonable doubt and what that really means. And we kind of just went over that. Conclusive and complete proof without leaving any reasonable doubt about the innocence or guilt of the defendant. And then something called clear and convincing evidence, and then probable cause and sufficient evidence and reasonable suspicion and less than probable cause. And take the time to go through and look at some of those, because I think it's important that you do that. And a couple of the bigger ones, the more things, the definitions that you'll see a little bit more would be what they call probable cause. Now, the U.S. constitutional standard for arrest and search warrants and searching requires the existence of facts sufficient to warrant that a crime has been committed. And that's probable cause. Now reasonable suspicion is rationale, reasonable belief that facts warrant investigation of a crime on less than probable cause. So read those definitions and get to understand them. So now that we've kind of walked through the court system and we've gone through some processes and we've talked about all the different courts that are out there, let's look at like the key players. So when you go to court, who are all these people in the courtroom and what do they actually mean? And again, I'm not going to go through every one of these because some of these are people that you know when you look at the name, like defendant. So like defendant, anyone actually, including a person suspected of committing a crime, has certain rights that must be protected at all stages of the criminal justice process. Now defendants have all the rights set forth in the Bill of Rights, and they may waive these rights, but if they do, that waiver needs to be in writing, because proof of the waiver is up to the police officer and the prosecution to provide that support to the court. And the police officer must be able to show that all the rights have been respected and that all required procedures have in fact been complied with. So these key players in this judicial process include the defendant and the prosecutor and the attorney and the judge. And we'll talk about what pro bono means, and sequester and jury and things like that. As a matter of fact, maybe we'll just take a quick look through some of those definitions, and then we'll kind of move on. So the prosecutor. When we know the defendant, that's the individual that is being accused of whatever crime might be there. Now the prosecutor, a head prosecutor, also known as the district attorney, county attorney, or attorney general, depending upon the level of government at which they serve, is an official elected to exercise leadership in representing the government and therefore the people in the criminal justice system. Now, prosecutors may be city, county, state, commonwealth, or district attorneys, or solicitors, and they are usually elected to a 2 or 4 year term at the state level, and at the federal level they are appointed by the president. And in some states, the prosecutors work hand in hand with police on criminal investigations. And although the head prosecutor is an elected person, this individual has the power to hire or appoint the prosecutor who works underneath them. And these are typically just the attorneys who most often prosecute the cases. And the head prosecutor chooses the cases to be prosecuted, selects the charges to be brought to court, recommends the amount of bail to be required for pretrial release, and approves any plea bargain or recommends sentences. So the prosecutor would be working with police officers and the evidence and everything else to prosecute the case. What about the defense attorney? Well, the defense attorney represents the accused in court, and lawyers who represent the accused have the same duties and obligations, whether privately retained, serving as a legal aid in the system, or appointed by the court. They investigate the circumstances of the cases and explore the facts relevant to their client's guilt or innocence. Now, most cases are assigned to what they call a public defender or a criminal defense attorney, and or even a private lawyer. Now, a public defender is a court-appointed, hired by the state or county government to represent people who cannot afford to hire an attorney. So a public defender, again, court-appointed lawyer hired by the state or county government to represent those who cannot afford to hire an attorney. And pro bono work is defined as work done for free, lawyers that volunteer their time to be public defenders. And an ombudsman is a court or government appointed official who represents the best interest of the public when investigating complaints of misconduct or violation of rights. And the judge, I think most of you probably know what the judge is. And I have a picture of the judge in the O.J. Simpson trial. Does anybody remember his name? It would be Ito, if you remember. And sometimes confused with the term judge is the term magistrate. Now, although most people think of trial judges when they hear the word judge, many different kinds exist. If a person comes to trial, he or she will already have encountered certain levels of the court system and judges acting within the system. And various types of judges and the function they serve really depends on the court to which they are appointed. Now, sometimes confused with the term judge is that term magistrate. In the United States, a magistrate is a judicial official in an appointed position who is authorized to hear and make judgments on particular matters. A magistrate has the authority to issue warrants and review arrests and is typically used for less complex hearings than those reserved for judges. In federal courts, magistrates are appointed by judges and conduct a range of judicial proceedings to help expedite the disposition of many civil and criminal cases. In state court, it is common for magistrates to handle the trials of civil cases up to a certain dollar amount, applications for bail, arrests, warrants, and the adjudication of petty or misdemeanor crimes. Now, judges have many important functions throughout the entire judicial process and can exercise great discretion by accepting or rejecting pleas, deciding in preliminary hearings if evidence is sufficient to justify prosecution or dismissing charges, determining whether to grant bail and if so, how much, and deciding whether to grant delays, presiding over the trial, giving jury instructions, and imposing the sentence if a defendant is found guilty. So the judges kind of differ. And the jury, you know what that is. Several different types of juries exist in legal proceedings, but one most people think about when they hear the term, trial jury is known as a petite jury. And this type of jury is made up of 6 to 12 of the defendant's peers or adults drawn from the community who decide whether the defendant committed the crime as charged in a criminal case. So, I mean, that's just a little bit about the jury. And when they talk about sequestering a jury, that means that's kind of a court-imposed seclusion of jurors outside of the hearing of the courtroom testimony, in which they are kept in a private location away from other people with restricted access to media and media reports so they can do their jobs as far as determining the guilt or innocence of somebody. And the grand jury, okay, and I'm going to try to make this kind of easy to understand, and then we really got to get going. A grand jury is a group of 16 to 23 adults or adult U.S. citizens summoned in federal criminal cases to determine whether enough evidence exists to send a person to trial. Now, the U.S. Constitution requires an indictment by a federal grand jury before trial for most crimes against federal law. The consideration of a felony charge by a grand jury is not a trial, and an indictment is not a guilty verdict. An indictment is simply a finding of probable cause to believe the accused has committed the crime and that they should put on a trial. Now, the grand jury meets in secret sessions and hears from witnesses and victims of a crime, and contrary to the popular portrayal of grand juries on TV and in the movies, suspected offenders are usually not heard, nor are their lawyers present to offer any evidence on their behalf. Generally, only the prosecution's evidence is presented and considered by the grand jury. So that's just kind of some different key players that are in there. So let's walk through the different stages of the criminal justice process, and we're going to have to kind of get moving so we don't take a little bit too long. So the criminal justice process consists of the steps that occur between and include the filing of the complaint through the acquittal or sentencing of an offender. And an acquittal is a formal certification by the court stating that the accused is found not guilty for the crimes he or she was charged. The charges are dropped and the defendant is released. And a bench trial is a trial by judge, not by a jury. And this is kind of what the diagram looks like. So if you look up at the very top, you can see complaint made by police or officer arrest. Now, it can be dismissed, or it can go down here, which means that the complaint is issued by the prosecutor. We're going to file the case, or a warrant is issued by a magistrate, either one. So you've got the arrest, you've got the booking. Now you can be released on bail, or if it's a misdemeanor, you can go to muni court and you can do a guilty plea, or you can do not guilty, pretrial hearing, you can go all the way down, or you can go the felony side, which is the preliminary hearing, and then it can be dismissed. and then depending upon where you're at, it could go to the grand jury, or it could go to this arraignment and then to a trial all the way down, and you can either be acquitted or sentenced. So this is kind of a schematic, if you will, of the criminal justice process from complaint to disposition. So we looked at some of these, a crime, a warrant, arrest, booking, initial appearance, bail, charging decision, which is the complaint. It's a legal document that specifies that an alleged crime and supporting probable cause facts exist. And then the next thing that could happen would be what they call a preliminary hearing. Now, along with that chart that I just showed you on page 547, on page 548 would be basically a bunch of different pleas that I'll also walk you through. And it's a diagram of law on the books versus law in actions, the steps in the criminal justice process. So it starts with crime and arrest and initial appearance and bail and preliminary hearing, etc., and it walks you through. So we've already gone through some of these here that we talked about. Well, the preliminary hearing, this is a little bit bigger now, or grand jury hearing, but we're going to talk about preliminary hearing. This is where the judge determines whether there is probable cause to think that an offense has been committed. And both sides can present limited evidence, if you will, and a couple of witnesses, but it's not the full-blown trial. It's enough to basically decide, hey, is there probable cause to believe this person committed the crime? And if there is, then the case could be moved on for trial. And if there's not, then the case could actually be dismissed. But this is where they present information at this case. So some of the outcomes, again, it can be dismissed, it could be moved to trial. They're going to present this information, or it could go to a grand jury depending upon the process. And the arraignment is where the person is informed of the charges and they enter a plea. And the plea can basically be guilty or not guilty, or a no contest plea. But again, at the arraignment, this is where somebody is going to be basically read the charges against them, and in its definitive stage, it's when defendants are charged with a felony, they must personally appear at this arraignment, and as in the preliminary hearing, they're entitled to counsel, and the procedures of the arraignment, again, they vary a little bit, but this is where the complaint is read, and if they haven't received a copy, they get one, and then they enter a plea. And there can be a plea of what they call, well, first there can be something called standing mute, meaning they don't say anything, refusing to answer. And that basically by the judge is going to be a not guilty plea. There's something called nolo contendere, which means no contest. And by entering a plea of nolo, in essence, they're saying that they're throwing themselves on the mercy of the court, and they don't want to say they're guilty, but it's assumed a guilty plea. And then, of course, a guilty plea means that they admit to the charges, and not guilty means that they don't. So that nolo contendere, again, I know it's confusing. It means that they're not going to contest it, but basically it is a guilty plea in essence. And then part of the after the arraignment and things, there's going to be some other terms that come about. There's going to be something called discovery, which is an exchange of information before the trial. There are going to be pre-trial motions, which is where the defense may try to have evidence suppressed because it was collected or obtained, maybe in violation of the Constitution. There may be plea negotiations where the defendant pleads guilty with the expectation of receiving some kind of benefit. And then there may be the actual trial. The case may go to trial. And the trial is a fact-finding process using the adversarial method we talked about before a judge or jury. And then finally, there's the sentencing appeal, which is a review of the lower court decision by a higher court. So some terms, again, because there are a lot of terms as we go through here. A complaint is the legal document drawn up by a prosecutor that specifies an alleged crime and the supporting facts, providing probable cause. Bail is usually one right of the accused and is the right to be released from custody in keeping with the legal premise, innocent until proven guilty. But now it's a right, but keep in mind, not everybody gets bail. There are some cases where you're not going to get bail. And then a writ of habeas corpus is a legal court order where a person can be released if they believe they are being held in custody illegally. So again, we're not walking through the entire process piece by piece, but I do want to make sure that you get some of these terms. A no bill is what is issued by a grand jury if it decides that no crime has been committed. And an indictment, remember, is issued by the grand jury if it believes that, in fact, a crime has been committed. The term nolo contendere basically means I won't contest it, but it does not directly admit guilt, but it submits to sentencing or any other punishment. So what about some alternatives to trial? What are some things that can happen? Again, without walking through all of these things, what are things that can happen instead of going to trial? And before I jump into this quickly, remember page 548 talks about the steps in the criminal justice process. So it starts from crime, arrest, initial appearance, bail, preliminary hearing, arraignment, discovery, pretrial motions, plea bargaining, trial, sentencing, and appeal. It walks you through, and it gives a little description as well. Well, what are some ways that we can maybe avoid a trial? And, a relatively small percentage of all criminal cases go to trial. And you have to kind of thinking about it. And before cases go to court, prosecutors and defense attorneys explore the possibility of what they call diverting the case from the criminal justice system, or negotiating a plea bargaining. And so diversion is bypassing the criminal justice system by assessing an offender to a social service or social agency other than the institution of going to trial. So diversion, bypassing the criminal justice system by assigning an offender to a social agency, and it provides expanded options with which to respond to criminal behavior. And some types would be maybe that the prosecutor won't press charges if some programs are completed, or the prosecutor might suspend charges and drop those charges at completion of a program or something, or a guilty plea is dismissed if a program is completed. And these are just a couple of avenues that are discretionary and within the prosecutor's purview to basically show some alternatives to going to trial. So plea bargaining, here's kind of another phrase that's out there. We talked about diversion. Well, burdensome caseloads facing most courts put pressure on everyone involved in the courtroom work group, defenders, prosecutors, judges, to resolve their cases quickly. And how do they do that? And commonly they do it through what we call plea and charge bargaining. And plea bargaining and charge bargaining are legal negotiations between the prosecutor and the defense lawyer or the defendant to reach an agreement or compromise that basically avoids a court trial. And I hate to kind of tell you, but remember a few minutes ago I told you about the fact that not all, the majority of cases don't go to trial. Well, typically, in actuality, nearly 95% by some estimates, cases are disposed through plea and charge bargaining and not by court trial. So a plea bargain is a legal negotiation between the prosecutor and the defense to reach an agreement or compromise on the plea to be entered by the defendant as a way to avoid court trial and to conserve time and expense. Well, charge bargaining is kind of the same legal negotiation between the prosecutor and the defense to reach an agreement or compromise on the charges to be filed in a case as a way to avoid a court trial and conserve time and expense. So what happens when we reach the trial? Well, that's kind of the end, sort of. The trial is the climax in the criminal justice procedure. And how well the police have investigated the case, compiled the evidence and reported it, and dealt with the victim and witnesses are kind of weighed in the courtroom, because the jury or the judge may have to make a decision based on what I just said. And the trial also, for the most part, tests how well the prosecutor may have actually prepared their case. So kind of an interesting thing when you talk about the trial. And remember, when we talk about trial, a judge, there's a jury trial, we know that, but a trial with just a judge is called a bench trial. And by law, you have the choice of a jury trial, a trial by your peers, or you could select a bench trial. And at a jury trial, there is going to be this thing called jury selection. And that's where I put this video in at the very beginning to talk about jury selection. Now, there's a lot of safeguards built into the jury selection process to protect the defendant's rights and ensure the public that justice is done. And trial jurors are selected at random from voting or motor vehicle or telephone directories by district or superior court judges or the commissioner of the county board. And if you watch this video, you'll find a little bit more information on jury selection. And there's a phrase called voir dire. And this is basically the random selection of potential jurors and the careful questioning of each. And as these potential jurors come through, each side is allowed to ask a certain amount of questions. And sometimes those questions may bring forth some bias or something on perhaps one of the possible jurors, and that juror can be basically excused. And there's a couple of different ways of doing that, and we're not going to get into all of those different aspects, but if you watch the videos, it will show you exactly what I'm talking about. And then if at the end of the day, after the trial's completely done and testimony has been given, and testimony is that information, where people get up and they talk about, if they're witnesses or victims, and then there's cross-examination where both the defense and prosecuting attorneys get to cross-examine witnesses, and then there are closing statements where each attorney gets to give a closing statement, if you will, and present their case in one final case summary, and there are procedures built in for how they do that. And then they're going to have what they call a verdict. And the verdict could be guilty, which would be one. It could be not guilty. Or it could be what they call a hung jury, and that's a jury that can't reach a decision. The result is basically a no verdict decision that can result in a retrial. And so remember, if there's a disposition on a case, if someone's guilty or not guilty, that person can't be tried for that same crime again. But if it's a hung jury, meaning that they can't decide, then the prosecutor can decide to retry that case. And then there's the sentencing portion, and the continuum from probation to intermediate sanctions, to jail, to prison, to death, depending upon what the crime actually is. And if you look on page 555, you'll see that sentencing continuum that starts at probation and then intermediate sanctions and jail and prison and death and all of the things in between. And there are sentencing guidelines that are built into the criminal justice system to deal with disparities and things like that. And then finally, there is the opportunity for cases to be reviewed and appealed as well based on procedural or prosecutorial or even defense attorney conduct or bad procedures or any other type of issue that can be constitutional. And here's kind of a look at the sentencing guidelines, if you will, that I talked about. So your sentence could actually fall anywhere in the guidelines that you see on this particular chart. So the last piece here, and I know we're running over, is going to talk about the police officer in court and the importance of that. Now, preparing a case for prosecution, it's important to review all the evidence, good and bad, and the chain of custody, and review all the reports on the case, and review all documentation that may be requested by the defense, like speeding tickets on radar and things like that, and review training that may be called into question. So if perhaps it's a DUI arrest, maybe you need to review your training file so you're able to appropriately discuss the training you've had on the recognition of persons under the influence and things like that. And then there's the time to prepare your witnesses and get them prepped for trial, and even a pre-trial conference with the prosecutor to make sure that you are well prepared and all of the witnesses are well prepared. And appearing as a witness, most departments have regulations on what you should wear. What type of attire do you wear when you go to court? Well, some specifically say uniform, and some say gun or no gun. And maybe you could kind of think in your mind, if you came in wearing your SWAT uniform with your helmet and all your SWAT toys and stuff, you might be kind of looked at as kind of a militaristic type person, so maybe you don't want to dress like that. And this is really important, the way you look, the impression that you make, because the jury can basically, by inference, the way you look, the actions, the thing you say, the way you speak, how you come across, can impact the credibility that they have and the perception that they have about you. And fair or not, they are allowed to use that. And along with that, officers should not discuss the case in the hallway while they're hanging out waiting to maybe testify. And the reason is you don't know why, or you don't know how, or whether other people that are relatives of the defendant or other attorneys might be out in the hallway, and you might say something inappropriate or something that you shouldn't. So, basically, you just should keep to yourself and be very polite if somebody talks to you. And if you believe that it's, keep your conversation short and try not to get involved in any extracurricular activity in the hallway, if you will. So when you testify under what they call direct examination, speak clearly and firmly and with expression, and answer your questions with confidence, but don't volunteer information. Only ask what is asked. Briefly pause before answering. Don't just, think for a minute if you have to before you answer. Refer to notes if you don't remember something. You don't want to get caught making stuff up. And if you don't know, the answer should be, I don't know. And admit calmly when you don't know. And, admit your mistakes in testifying. Well, you know what? Now that I think about it, it was in fact a dark gray car, not a light gray car. And avoid police jargon, the 10 codes and all those funny words that we use sometimes when we talk in policing. And under cross-examination, remember that the defense attorney might be very friendly or a little bit rude, as a matter of fact, and they're there to attack the officer's credibility and your knowledge and your investigative skill, and attempt to force contradictions or show the jury there's some inconsistencies. They might even ask leading questions or misquote what you said. And for a simple answer, or ask for a simple answer to a very complex question, or basically kind of stand there for a minute and not really say anything to kind of get you to fidget in your seat. So usually it helps to, establish elements of the crime by testimony and evidence. And preparing a case for prosecution, remember, we have to prove the case beyond a reasonable doubt, and sometimes that's why it's good to have that pre-trial conference, and where all evidence is reviewed, so we really understand, what it is that we're talking about. So I know that was kind of quick. We went just a little bit over, though. Do me a favor, go back into the textbook and look at some of the definitions, the key terms. Specifically, I would ask that you go back and look at a couple of the charts. The chart on page 548 that talks about the steps in the criminal justice process. Look at the chart on page 547, that is the criminal justice process from complaint to disposition. And these charts will definitely help you. Look at that graphic or chart on page 541 that talks about evidentiary standards of proof and their degrees of certainty. So with that being said, that's going to end our lecture for chapter 13. And of course, if there are any questions, post them on the general discussion board. And if you don't want to do that, you can send me an email. And other than that, until next time.